We've talked about a bunch of times about the potential antitrust violations involved with tech companies. There are many videos online on YouTube and also some article claiming that various tech companies, specifically the social media companies, may be liable under antitrust law because allegation that they are colluding in their deplatforming of some accounts. The latest call for lawsuits when it comes to antitrust proceeded the banning of Alex Jones, saying that why are so many platforms basically banning him one after the other? Is that an indication of some form of collusion? Can you sue them for antitrust? I was just watching a video maybe an hour ago claiming this was antitrust violation. We did speak about antitrust, I think, in the past 2 months. Specifically, obviously, it was theoretical because there was no lawsuit yet. It was about the potential antitrust violations when it comes to Google. I'll leave a link up above. You should be able to see the little eye that tells you, I give you a link to that prior live stream as well. But today we actually have a lawsuit in front of us. Let's just jump in right away and just take a look at some of the elements before we get any further into it. And this is what's in front of us. It's a lawsuit in Washington, D.C. Freedom Watch versus Google, Facebook, Twitter, and Apple here. Now, a couple of things before we start. Freedom Watch. Now, let's be clear. I've never heard of Freedom Watch. Didn't know anything about it. As part of this, I see a lawsuit. I look into what Freedom Watch is. So all I know is what I've read online, and I'm going to take it for granted that you don't need me to regurgitate what other people have said about a party or who they are, because that in itself can be biased since I don't have any personal knowledge of it. But let me give you a very broad overview of some of the stuff. You can look it up yourself. Freedom Watch is basically a conservative watch group. It started out by a single individual, and his name, and I apologize for forgetting the individual's name. Where is it here? His name was Larry Klayman. He started out another organization that was called, I think, Justice Watch, instead of Freedom Watch. Justice Watch, something like that. And as part of that organization, he filed numerous lawsuits against liberal causes. A lot of lawsuits against the Clinton, like multiple lawsuits against the Clintons for various reasons, but for other things that he felt conservative elements and conservative causes were being harmed as a result of some liberal stances. My understanding, I don't have any personal knowledge of it, that most of those lawsuits were lost, but as part of it, he was successful enough in getting Freedom of Information Act, forcing government to release information or forcing the other parties to release information as part of those lawsuits, and the release of information has been valuable in and of itself. He is no longer with Justice Watch. He has formed a new company, and this is one of the lawsuits involved here. Beyond that, you know, you guys can research the man and the group itself. It doesn't really add or take anything from this particular lawsuit. It really doesn't matter what are the motives, who is the party, why a lawsuit is filed, whether or not that lawsuit is intended as a lawsuit that can be won, or one that's just intended in order to be able to generate more information through Freedom of Information Act requests or discovery in a lawsuit. That really doesn't matter for our discussion, because ultimately we want to see whether or not he has hit on an idea that can actually catch on fire, can actually get people anywhere, somewhere. Because until now, we've seen time after time different lawsuits against this platform fail, and not just fail because they went through the entire lawsuit and then received an unfavorable decision. they failed at the very initial phase. Virtually every one of these lawsuits against platform, Facebook, YouTube, Google, Twitter, fail at the motion to dismiss. Basically, the plaintiff files their complaint. Most of the time, the defendants never actually file an answer. Right away, they file a motion to dismiss. There might be an argument over the motion to dismiss. The courts rule. All of these lawsuits have been dismissed. And we've talked about it many, many times about why these particular lawsuits have been dismissed. There's been two causes. One has been Section 230 of the Communication Decency Act. The other one being freedom of speech argument. Before we get into the entire thing, let's just clarify a little bit about the Section 230. Basically, in 1996, a law was passed called the Communication Decency Act. That entire law basically get thrown out by the Supreme Court. It basically restricted, it's a law that attempted to restrict our ability to use inappropriate words and create what would otherwise be obscene material online. Obviously, the Supreme Court, having looked at it, said none of that is constitutional. It interferes with the public's right of free speech. So the entire law was thrown out, with the exception of this Section 230, which really is the only remnant of the Communication Decency Act, which pretty much creates this umbrella, this complete indemnification, complete umbrella protecting online platform from any liability associated with third-party content, meaning anything their users are putting online, these platforms are not liable. But more than that, they're also not liable for their own action with respect to third-party content. So any decision they make with respect to a user content, they ban that content, they raised its prominence or completely demote it within the search capability. They monetize it or demonetize it. They shadow ban it or anything like that. None of that can be touched under Section 230. The law basically said that these platforms are allowed to make any decision with respect to third-party content without any liability. Section 230 has been the prime reason why none of these lawsuits have gone anywhere. All the lawsuits against Google, Facebook, Twitter, and a lot of scores of other platforms and online services have failed at the initial stage, largely because of Section 230. Secondary to that has been the concept of freedom of speech. The idea being that all these platforms, in their decision, in their attempts to moderate their own platform, whether or not they remove somebody's content or remove somebody's account, remove somebody's access, or they demote their content, that's the expression of those corporations' speech. They are allowed to express themselves as a corporation, and as a result, you cannot sue them for discrimination because that's their freedom under the U.S. Constitution. That's a huge subject in and of itself, and I actually have I'm planning a video because I was reading a book. You could probably catch it here. It's in the list of books that in the description that I'm reading, called "We the Corporation," about the development of corporate rights, including corporate freedom of speech rights. And so it's a big issue that I want to discuss, not going to be for today. But then, nonetheless, Section 230 has been the prominent one. So if all these lawsuits effectively gets dismissed, what are we looking for when it comes to this lawsuit? So let's start with one thing. I'm going to assume that every fact alleged in this lawsuit is 100% true. First of all, I have no basis to actually take a look at any of the facts and say otherwise here. These are all allegations relating to how these different platforms are discriminating against conservative causes. I don't have any basis to say yes or no to it. I know as much as any of you know it. I've seen some of the testimony in front of Congress. I've seen some of the articles. I've seen some of the allegations. I've seen the effect on some of the conservative causes and their removal, let's say, off of the platform. So I don't have any basis to say whether or not any of these allegations are true and false. And for that reason alone, I'm going to assume everything is 100% true. And why is that valid, in my opinion, that kind of an approach? Well, because all these lawsuits until now never got to a point of actually discussing the allegation of discrimination, because they all get dismissed because there is this umbrella provided under Section 230. So you never get to that point. And when you look at motions to dismiss, you have to assume the truth of the alleged facts. It's part of what the courts does. So courts always assume that everything the plaintiff is saying is 100% true when they're looking at the motion to dismiss. So literally, the only thing we need to look at right now is whether or not this lawsuit can actually survive a motion to dismiss. We are so far away from looking at whether or not the facts alleged are true or not. That's something that can come out later on, not only through the discovery process, but through the trial itself. At this stage, can this lawsuit do something that really none of the other lawsuits were able to do, which is defeat a motion to dismiss? So pretty much, with one exception, which was a lower court decision in the state of California, which was a lawsuit by, I believe, Jared Taylor against Twitter, where he accused Twitter of actually banning him of discriminating against his viewpoint on their platform. A lower state court in California made a wrong decision. I told you that time it was just the judge did not understand how Section 230 actually worked. We discussed some of the discussion between him and the Twitter attorney, and even though he allowed the case to move forward, that was struck down almost immediately by an appeals court. So that was corrected. So all of these lawsuits end very, very quickly. So the question is whether or not under this antitrust theory, this kind of a lawsuit can move forward. The concept that discrimination somehow is unlawful when done by a private party within their private platform. So let's start with the case. It shouldn't take us too long to really go through it, and I'll describe some of the elements and explain some of the antitrust issues in this case here. So here again is the lawsuit between Freedom Watch against Google, Facebook, Twitter, and Apple. And it says, plaintiff Freedom Watch brings this suit as a class action. So obviously he's intent to allow other plaintiffs to join him later on because he wants to get a class action lawsuit going. The class is defined as all politically conservative organization entities and or individuals who created and or distributed media content and advocacy who have experienced illegal suppression and or censorship of their media content by defendants. Right, and then you see a description of the plaintiff, which is a 501c3 nonprofit organization incorporated within the District of Columbia. The reason this actually is very interesting. The fact that this non-for-profit is incorporated in DC, and this case is brought in DC, brings another issue, which is not an antitrust issue, which is going to be the third element in this lawsuit, which seeks to say that in DC, you can sue because you're not allowed to discriminate against political affiliation. We discussed this issue before. It gets complicated. Without getting too much into it, around the country, basically 48 states do not have political affiliation as a protected class, so you can't claim discrimination under those state laws for political affiliation. Federal law as well does not include political affiliation as a protected class. California and New York do have that, but only with respect to employment issues. And the other one, which is not a state, is the District of Columbia. District of Columbia does have a listing of political affiliation as a protected class. So the fact that this is out of DC is actually quite meaningful. We can discuss a little later here. Facts. Defendant suppression and censorship of conservative content. It has been revealed that defendant, each and every one of them, have engaged in a conspiracy to intentionally and willfully suppress politically conservative content. This conspiracy has resulted in severe financial loss as well as unconstitutional suppression of speech and other content for Freedom Watch and those similarly situated, acting in concert with traditional media outlets like CNN, Washington Post, and everything else. All of them are owned or managed by persons with a leftist political ideology. Defendants have intentionally and willfully suppressed politically conservative content in order to take down President Donald Trump and his administration with the intent and purpose to have installed leftist government in the nation's capital and the 50 states. Now, at that point, it gets into a lot of discussion of, I wouldn't say proof of discrimination and suppression, but rather the evidence being pointed to are other articles or other speakers, other people that have indicated suppression and discrimination. So it's not direct evidence, but rather pointing out that this particular article discussed suppression, and that particular individual discussed potential removal of conservative content, stuff like that. Nonetheless, like I said, if you go through it, and we're going to assume that everything said is 100% true. So we're going to skip basically a good portion of it, which gets into all the different claims of suppression and discrimination of conservative voices, because we're going to assume that 100% of it is true, because that's really is not the issue here. So here, let's just scan through here until we get to here, facts pertaining to directly to Freedom Watch. A couple of grammatical mistakes in the documents here, you will notice. Freedom Watch is a leading conservative non-for-profit public interest organization that operates its own website, a YouTube channel is Freedom Watch TV, a Twitter account, and a podcast on Apple's network. The chairman and general counsel of Freedom Watch, Larry Klayman, is also the founder of Judicial Watch and previously was a trial attorney and prosecutor in the Antitrust Division of the U.S. Department of Justice. He was an integral member of the Antitrust Division trial team that broke up the AT&T monopoly during the Reagan administration. Let's look here. Freedom Watch has experienced steady growth in both audience and revenue generated through these platforms for many years until the recently reported suppression of conservative content set forth above, all the different evidence that he was claiming above, which grew more pronounced and severe approximately 6 months ago. Basically, he's going to start discussing how he has certain growth when it comes to, let's say, his YouTube channel, and everything just stopped, right? Because beyond the claim, obviously, you can't just file a lawsuit on behalf of everybody else. You have to claim that you are yourself is a plaintiff, you've been aggrieved. So Freedom Watch is claiming that they were aggrieved, that they were the victim of suppression and discrimination by these platforms and tech companies. Apple is not really a platform, although, you know, iTunes is in the app stores. In that sense, they're kind of a platform. But the idea that they themselves are a plaintiff, they were harmed, their revenue potentially was harmed because their subscriber growth has plateaued. Not clear whether or not viewership has plateaued as well and how that impacted advertising revenues or other revenues. Generally, when you're claiming damages, you have to tie it to revenue, not to subscriber growth, which generally does not really have revenue associated with. So that information is not available. But let's assume that just in line with the subscriber growth, so is revenue and so is viewership plateaued or maybe even declined. We'll assume all of that as well. And here we get into the heart of what is being claimed as part of the antitrust allegations here. Defendants' market power and antitrust allegation. Defendants have entered into an illegal agreement to refuse to deal with conservative news and media outlets such as Freedom Watch and those similarly situated, as well as to suppress media content and advocacy which has no legitimate business justification and is plainly anti-competitive. Now, the words used here are chosen specifically, not just, you know, nice writing. The reason why they discuss things like legitimate business justification and things like that is because that's going to play into elements within antitrust law. I'm going to get into it specifically in a couple of minutes here, but just be cognizant of that. Defendant's agreement has a plainly anti-competitive effect and has no rational economic justification, as they are willing to lose revenue from conservative organizations and individuals like Freedom Watch and those similarly situated to further their leftist agenda and designs to effectively overthrow President Trump and his administration. Alternatively, defendants who are and should be competitors to each other have engaged in conscious parallelism, we're going to discuss that in a second, insofar as they have each mimicked each other refusal to deal with Freedom Watch and those similarly situated in order to set control and establish the relevant market. And then again, there is no legitimate reason for any of that that's being declaimed here. And number 74, defendants collectively have obtained monopoly power in the relevant market through exclusionary conduct that has severely harmed competition. And now we're going to get into the causes of action. The first one being a violation of Section 1 of the Sherman Act, illegal agreement in the restraint of trade. Which brings us to, let's start discussing antitrust law. Okay? It is not illegal to collude in and of itself. It's illegal to collude in a way that causes anti-competitive impact on the market, on competitors themselves. It's not illegal to be a monopoly. It's illegal to act like a monopoly. And that's really what we're dealing here in what is going to be called Section 1 and Section 2 of the Sherman Act. Let's take a look at the wording, at least part of the wording of Section 1 here. I apologize, I'm going to put the words right on top of me. Every contract, combination in the form of trust or otherwise, or conspiracy in restraint of trade or commerce among several states or with foreign nation is declared to be illegal. Okay? Every contract in restraint of trade is going to be illegal here. Now, the courts have said it's more than just contract. It might be behavior that is contractual in nature, not necessarily a written agreement every single time. But basically the idea, it's illegal to effectively have an agreement that is going to harm competition, harm trade. That's going to be Section 1. Section 2, which is going to be discussed a little down the line, says every person who shall monopolize or attempt to monopolize or combine or conspire with any other person or persons to monopolize as part of the trade or commerce shall be deemed guilty of a felony. Again, it's not illegal to be a monopoly, but it's illegal to act as a monopoly, right? Which there are certain acts, predominantly pricing behavior. It's illegal to, as a monopoly, to control pricing. Let's say drop pricing to kill competition, and then after, once competition is dead, to raise it. Behavior, not necessarily status. That's what illegal. So that's the two elements of antitrust that we have to discuss here. Now let's go back to the lawsuit and see what they discussed, which is the first one, which is the Section 1. Section 1 of the Sherman Antitrust Act states that every contract combination in the form whatever is illegal. Defendants, each and every one of them, have conspired and illicitly agreed to refuse to deal and suppress media content and advocacy from Freedom Watch and those similarly situated of the class. So it's a claim that they have conspired and illicitly agreed to refuse to deal with conservative companies. Alternatively, defendants, each and every one of them, have engaged in conscious parallelism in concert, mimicked each other's refusal to deal with Freedom Watch and those similarly situated. So what is being said here? Well, the classic form of antitrust violation under Section 1 is when you find that two or more parties colluded, where you can find evidence of an agreement, a written agreement, maybe a verbal one if you have a recording, but you have an actual agreement between parties to do something anti-competitive. So the first claim here is that there is an actual agreement between the parties, Apple, Facebook, Google, Twitter, to act anti-competitively. Now, let's be honest, there is no evidence of that, right? There's no evidence of an actual agreement. Again, we're talking about either a piece of paper or a recording that says that we got together as some sort of a cabal and we agreed that we are going to do X, Y, and Z to when dealing with conservative watches. So it's a claim, but it's not realistic. It's the second one that is really at the heart of the issue, which is what is being called here conscious parallelism. Now, what is conscious parallelism? The idea is, and that's probably what many of you have called for when you saw what happens with Alex Jones, which I think you could argue conscious parallelism in. That when you look and you see all the parties, they may not necessarily have a real agreement, right? They may not have, they shook their hands or wrote down an agreement, this is how we were going to behave. But one party acted, another party saw what they acted, and they did it as well. Another party acted, meaning they see how each act, they take it as kind of a pseudo-agreement. They never discuss it, they never actually shake hands or sign anything, but they kind of like through a wink, they act in concert. That's what the concept of conscious parallelism. And it's something that courts have recognized in the past. Now, so there are two allegations, one being a true agreement, which is probably not true, or at least there's no proof of it. It might be once, if there might be some elements of that once you go through discovery. But the heart of this argument is really conscious parallelism. We can see that all these parties are acting somewhat in concert, even if they don't have a real agreement. It's kind of a wink and a nod, and that's why they're doing it. That's the concept there. Defendants are losing significant revenue from conservative groups and individuals like Freedom Watch and those similarly situated members of the class. Defendants are accepting this temporary loss of revenue in order to set control and dominate the relevant market. Now, what is being claimed here? Well, think about the first kind of antitrust where there's a real agreement. And where do we see that kind of an action? We see that in OPEC, right? OPEC is a classic. If it happened within the United States or within much of the developed world, that would be illegal. OPEC is basically collusion among member states to control the production of oil, keep production lower than really what would balance the market. As a result, keep prices higher, right? So there is an actual agreement. It's just that, international law cannot, at least chooses not to go against OPEC because they have such market power. But nonetheless, it's a real collusion, an agreement among the parties to actually choose their profits over effectively the market by reducing output and increasing prices. Now, very common when you got those kind of collusion is that somebody cheats. And that happens with OPEC all the time. A member cheats. Why? Because it's in the economic interest of an individual member to always cheat when it comes to collusion. The group has a purpose, and if everybody sticks to it, the group benefits, right? They all stick to it, they all keep production costs low and prices high. The group as a whole benefits. But if you're a member within the group, it's best for you to cheat because prices are so high. You want to flood the market with as much product as possible at that higher price. Hopefully you're not impacting the prices that much and you can sell a lot more. So there's always an interest for the individual member within a collusive structure to cheat here. Now, we probably don't have that kind of a structure here with actual collusion, kind of a cabal sitting around a smoky room making decisions. Most likely, if we have anything, it's going to be conscious parallelism with a wink and a nod that this is taking place. Now, the problem is that when you see companies act, right? You saw Apple drop Alex Jones, you saw Twitter maybe a couple of weeks later, but you saw Facebook and other platforms drop him. You saw their behavior, but you don't know if that's evidence of an underlying agreement. You just see that they are behaving in a certain way, but you don't know if that's evidence. And different parties, different courts, different judges, different legal experts, professors have looked at that differently. Some said, well, if we can show that there was conscious parallelism, that should be de facto or per se antitrust. That was collusion. That's kind of difficult because there's a lot of genuine reason why businesses look at what their competitors are doing and they're following suit, and that's not necessarily collusive behavior. That might be genuinely good reasons to do that kind of action. For instance, I see that a competitor is raising prices. I choose to follow. I'm not colluding with him. I'm doing it because I see an opportunity. So there is this kind of, not every time I follow what a competitor is doing, that would be illegal. So there have been different legal theories developing on whether or not it should be a violation per se, or should we look for something else? Should we then use information like everybody in banned Alex Jones? Should we use that as the basis then to actually look for an agreement? Or should we find something else? And that something else has been, the courts, when they've looked at it, is this what's called a plus factor. The idea being that if a party acts against its self-interest, that together with conscious parallelism be proof that they colluded in a manner that would be otherwise illegal. For instance, go back to OPEC. It is, while the group, everybody within the group, there's an incentive to remain loyal to the group because the group as a whole benefit. The economic incentive of the individual member is to cheat, and that's why it happens all the time. So if you can prove that an individual member is doing something against his interests, that would support the idea that there was collusion. Easy within OPEC because we know it's a collusive structure to begin with. Same idea here. If you can show that all these platforms, Apple as well, technology companies, acted in concert, but you then would have to show that each one acted against its own interest as proof that they colluded. Because if they're acting in a manner that has a legitimate business reason or in its own interest, not against its interest, then you're not really getting evidence of collusion. That's the legal theory behind it here. So he's trying to say in this that we can see conscious parallel. They followed each other, and there was no legitimate business reason for them to have done that. That's what he's trying to get into. Now, with all due respect, he didn't really flesh out that idea, right? This is something, as you can imagine, you can talk a lot about. You know, why is it in their interest or not in their interest? What's the potential business implication of doing it or not? And none of that is being dealt with here. So it's kind of, the lawsuit does not have as much as probably it should to really give some meat to that argument. But that's what he's talking about. And when you look at it, the issue with this is this. Yes, we can see that they're all acting in concert. But are they acting against their business interests? There is some indication in the lawsuit here that by excluding the conservative voices, they're acting against their interests. Somehow they are, if they allowed all conservative voices, they would be making more money. So when they exclude it, they are actually causing themselves, Google, Twitter, and Facebook, somehow they're causing themselves to lose money. Since no rational economic player would want to lose money, that's against their interest. Now, that's not a very well flushed out idea, because you'd have to argue, well, why are they losing money? If I'm excluding them, if what I'm giving out is a free access to a platform, right? If it's YouTube, uploading is absolutely free. There's no cost to it. If it's Facebook, if it's Twitter, it's a free platform. And so I'm not making money off of my users. I'm making money off of my advertisers. So why am I losing money by excluding them? That idea was not fleshed out at all, right? There's no discussion of, well, there's a whole contingent of conservative advertisers who would put money into those platforms, but are rather now withholding it because they don't have a place to put it because all the conservative content is not on it. That might be an argument, but that's not really discussed. So it's like, so he needs to have this discussion of let me just check because I need to make sure everything is good here. He needs to have a discussion here over why they're acting against their interest in order to prove that they're colluding, but he's not really getting into that entire discussion. Now, second element here. Even if you can prove collusion, the only kind of collusion that would be illegal is one that's anti-competitive in nature. And that's also an element that's not well developed in the lawsuit here. Because you would have to argue that by excluding conservative voices, they are somehow killing their own competition. Now, normally, when you talk about anti-competitive behavior, and we discussed that in the past, the courts over the last 20, 30 years have looked almost exclusively at pricing. The idea being that if I kill the price in order to kill the competition and then raise it, that's anti-competitive. Sometimes you look at non-pricing issues as being similar in the sense if I cut, let's say, distribution ability for competitors, or I kill supply lines for competitors, that could also be, because it's kind of tied to pricing and the delivery of products. But in this case, they would have to argue, and that's what he kind of argues, that let's say YouTube is in direct competition with other content creators because YouTube creates some of its own, let's say, content, although he didn't really get into it, that YouTube now becomes a competitor of the actual content creators. And when it kills conservative voices, it's actually benefit itself because it's killing competition. So you'd have to not only argue collusion, but anti-competition. Not the anti-competition in the marketplace for ideas. That's not what antitrust is. But anti-competition in the commercial sense, right? I'm killing the competition. I'm killing either direct competitors, or I'm killing, let's say, downline distributors, or I'm helping, let's say, my own distributors win over their own competitors. You have to win that. So there's some lack in discussion there, really a development of that argument. He makes some hints to it, I have to admit, but it's not a really well-developed argument. The second one, right, and we'll jump in. I'm sorry it's taking longer than I thought originally. Discussion, just it's a complicated issue, and so I apologize. Is Section 2, and Section 2 is about monopoly, right? It's not about collusion in an anti-competitive way. It's about acting in a monopolistic way. And to get there, he gets a lot of description, a lot of data about whether or not each one of these companies is a monopoly within its own sub-market. And, you know, you can have that argument. You can have an argument, and that's something we left up to the trier of fact, that they're obviously not monopolies because they're all competitors of each other. Or you can argue that within very, very specific lines of business, they are the dominant player, and as such, either a monopoly or potentially an oligarchy, one or two players within that. But more importantly, you have to argue that their actions, because again, being a monopoly is not illegal, you have to argue that their actions is monopolistic and illegal in that sense. And for that, again, you'd have to get into an argument that somehow they manipulated pricing in such a way to harm competitors. Once again, that argument, just like in Section 1, is not well developed, so you don't really have that. So what you have here is a question whether or not this case can survive a motion to dismiss. And if I just give you my opinion before we get into all the different comments, is that I think that it'll be extremely difficult for it to avoid dismissal here. And that's because, like I said, under Section 1, even if you can show conscious parallelism, there is no really developed indication of this company acting against their own self-interest, because absent some argument that they are losing money by not allowing conservative voices on their platform, and as a result it is against their economic interest to exclude them, there is legitimate business reason, at least as claimed by those platforms, saying that, you know, we want to make, let's say, advertisers happy. Advertisers don't want to put their money against some of the more extremist voices. So this entire action is designed to align our interests with the parties that actually are paying us, which are the advertisement. I'm not telling you that's true. I'm just telling you that will be a legitimate business reason from a legal perspective, even though you may not consider it legitimate. So I think that there's a real, at least the way it's developed right now, a lack of focus on why their action is against their own self-interest. And then also the idea ultimately that it's hard to argue, at least there is no development argument of why what they're doing in their collusive behavior, even if you can get to that portion, is actually anti-competitive. The idea being that it somehow kills competition, their own direct competition. You'd have to develop this concept a lot more of why YouTube is somehow a competitor of actual content creators on its own platforms. So absent a real developed idea there, I think it's going to fall back to Section 230, and in all likelihood this is something that will get dismissed. It doesn't mean that the idea cannot be developed down the line or through a response to a motion to dismiss or through an amendment. Absolutely, that's always left on the table. It doesn't mean that somebody else cannot develop this idea further, but given how this lawsuit has been structured so far, it's definitely lacking some of the elements to prove antitrust.
When the lights are out and you stumble in the dark, you kept pushing on, but then you went too far. When your ship has sailed and all your dreams are lost, everything is wrong, you feel like it's your fault.